everybody. If people start trickling in through Zoom, Mindy, just keep letting them in throughout the session. But I'm going to go ahead and get started. So this is Intellectual Property Basics. So my name is Jessica Pierpoint. I was Taurus until about a month ago, and then I changed it, still in the process. I am the Information Services Research Assistant and PTRC representative at WSU Libraries. And this is my session. So there we go. So a little bit about PTRC and our Obwa Library. We became a PTRC in 1991. We are the only one in Kansas and one out of 54. So I am the representative for Kansas. We're working to transition another person to kind of help lighten the load, so it's not just me for the whole state, but until end of February, it's about just me. So a little things we offer are, I do individual consultations. Right now that looks like this through Zoom. I also do it by phone. We have a collection dedicated to patents, trademark, copyright information up on our 3rd floor. I have brochures that the PTR sends me regularly to help update patrons that are looking to do some form of IP. And I've created research guides, which I'll kind of go over with you guys at the very end. I also offer classroom instruction or workshops, such as this 3-part session I'm doing with Marcia. And then we also sometimes do library displays regarding small businesses, PTRC information, just all sorts of things. And we try to do outreach as well. So going right into it, what is intellectual property? There are 4 components that all make up forms of IP. And those are patents, trademarks, copyrights, and trade secrets. So intellectual property is a creation of the mind to which the creator has rights and may apply for protection. Patents, trademarks, and copyrights are the ones that you tend to see most frequently. Those you actually can apply to protect. And then trade secrets, it's still a form of IP, it's just gone about a little differently. So just kind of an overview. One thing that I like to do is show an example to kind of get us started. So I'm sure some of you guys have a cell phone lying around. So if you pick up your cell phone and you look at it, no matter what type of phone it is, you're holding all 4 types of IP in your hand. So what that looks like is kind of this slide. So patents, it can be from the touch screen. It can be, if you have an old school phone that has an antenna, it can be the speaker, the housing device, the battery power control, the shape of the phone. Those are all patent related. Trademarks for, in my case, I can't get my screen off right now, but as you can tell, oh, there we go. There's an Apple. So the logo itself is trademark. If you have an Android, it might have a different logo. Samsung might have a different logo. So all those are trademarked. The software can also be trademarked as well. So any of you guys that are maybe tech savvy and looking at protection for software, you might be considering multiple forms of IP. Then if you also look at the phone, there are copyright dynamics to it. So the coding to the software, not just the logo, but the coding, the instruction manuals that come with software, and the phone itself, that can be copyrighted. If you have a personal ringtone, that might have copyright aspects, as well as if you have music on it. And then the trade secret aspects are going to be the business model, maybe the algorithms to a specific app that you have on your phone. So this is just one example of something that's been created that has all forms of IP. And it's kind of like the brainstorm idea that I like to kind of get you guys started with. So now I want to take time to break down each forms of IP and kind of go over a broad overview and very basics into each one so that you can determine what IP questions you might have at the end. And also kind of, if you're looking to do some form of intellectual property, which area you might fall under. So first is the big one, patents. So what is a patent? A patent to the US is a property right granted to the inventor by the US Patent and Trademark Office, or USPTO. It has the right to exclude others from making, using, offering for sale, or selling the invention in the US, or importing the invention into the US. So patent, it begins on its filing date if it's granted. So not all patent applications are granted, but if yours does get granted, then it'll start on that filing date. There are payments and maintenance fees that you will have to do throughout, so that you can make sure that your patent stays irrelevant and stays current. And then there are some extensions that may apply as well. So there are 3 types of patents that I want to kind of broadly go over. The most important one, and approximately 90% of the patents that are granted are this type, are utility patents. So utility patents can protect a process, a machine, an article of manufacture, or a composition of matter. So if you're looking at creating some sort of device or invention that has one of those elements to it, then you might be looking at a utility patent. My example down at the bottom is a motorcycle. So the machine itself, maybe different parts of the machine, are all going to be utility patents. So with utility patents, you do have a 20-year term, and you can do a provisional patent application for this that would establish you earlier filing date by 1 year. So if you do a provisional patent, it's kind of like a rough draft, and it gives you that extra year window if you're looking to like really get the ball rolling. It might be something that you want to look into later on. So there are 2 other types, like I mentioned, of patents. One is design patents. So this protects the ornamental design or appearance. So my example for this is a chair. So even though a chair has certain elements to it that could be considered utility because of the way that it's created or certain dynamics of it, it can also be a design. So this is an example of a chair that has a desk attachment. So that desk attachment could be a design patent. The other patents that sometimes go through are plant patents. So these protect a new and distinct asexually reproduced plant. And for these, there is a 20-year term. So like I said before, these are just 3 types of patents, but sometimes if your invention has more than one dynamic to it, just like a cell phone, it could form other forms of IP, or you might have multiple patents that are under your one invention. You could have multiple utility, or you can have utility and design, just different ways to kind of think outside the box. So how do you know if your invention or creation is patentable? So here's a little 6-step thing that you can kind of think about. Okay, is this criteria fit my invention? So 1, is it useful? Does it serve a realistic purpose, works as it describes? Is it novel or new? It needs to have at least one unique claim that differs from any prior art. So you may find things that are out there that maybe have a similar, same type of invention as yours, but you need to be able to look at it and say, okay, this is why mine is different and this is how it is. So it might have a new physical change. It might have a new combination, use of previous inventions. So just kind of keep that in mind. It needs to be non-obvious. So would not occur to a person knowledgeable in the discipline. You need to look at the patentable subject matter. Is it full disclosed? Like, has it been disclosed before? Have you lost your 1-year window? Kind of things to keep in mind. Does it meet its time requirements? So these are things that you want to be thinking about to kind of get you started in terms of, does patent protection pertain to what you're looking at IP-wise? So why is it important to search for patents? So I mentioned talking about looking at other invention, prior art, and seeing if it is similar to yours. So one thing you're going to want to do is search. And why do we want to do that? Because you want to see the patentability of your invention. You want to know, has somebody created something like your invention already? And if so, how can you distinguish yours from theirs? You want to avoid infringement, because if you do infringe, most likely your invention won't get patented. Also, there's a segment on the application to which you have to say, these are the inventions that are similar to mine. So just kind of keeping that in mind. You want to discover how things work. If you're preparing to file an application, maybe you want to see what some patent applications already look like. You want to become familiar with the parts of a patent application. Like I said, this could be very useful, like looking at past patents, you can kind of get a feel for what the application looks like and what you'll need to provide for your own. So prior art searching, you want to consider any prior art that could be that could prevent a patent from being granted. So prior art is information disclosed to the public, and it includes all of these things from YouTube videos, blogs, social media, trade shows, presentations, databases, websites, books, journals. So not only do you want to think about looking at the USPTO database for your patents to see if there's anything that's been created like yours or similar, but you also want to look outside the box. Also, you want to make sure that you're not disclosing too much of your own invention. Otherwise, you might lose that window and you might not be able to get your own invention patented. So you want to make sure that you don't disclose too much about your own invention before you get too far into it. So next up, I want to talk a little bit about trademarks. So talked about patents. Patents are more about an invention, a creation. It can also be, other things. It could be a plant, maybe a flower, a seed that you have created. It can be a design element to a product itself that makes that product distinguished and different. But next we kind of want to look at the business side of things. So trademarks are very business entrepreneur oriented. You're looking at more logos, but other things kind of come into play to that as well, such as business names and other things. So we're going to discuss and dive deeper into that. So what is a definition of a trademark? So a trademark is any word, phrase, slogan, symbol, design, or combination. So it can identify a source of goods or service, and it can distinguish your goods and service from those of another party. There are multiple trademark symbols that you will see if you look at any type of business, company. These are 3 examples that are very simple and common known. So first up, I'm going to talk a little bit about register mark. So register mark is when you see an R and a circle, like the Pizza Hut, for example, in the little corner. This cannot be used before you register with the USPTO. So any company or business that has an R with a circle, they're theoretically supposed to be registered with the USPTO. So Pizza Hut, they have gotten their name, maybe even their logo or both, registered with the USPTO. So therefore they get to use the R with the circle. A trademark can use the symbol TM. So this means that they're claiming rights to the mark for tangible products and goods. So maybe they have trademarked, but they haven't registered it, or they're in the process of getting it registered. So right now they're just using the TM. So Subway is an example of this. They have the little TM at the bottom of their Y. Now I believe that they have registered, so they could theoretically put the R in the circle. You will see some places that maybe, I've seen this on McDonald's cups before, where maybe they have the TM on some of their merchandise or cups wrappers, other things, but then they also have the R with the circle. This could also mean that maybe they got it trademarked and they had a ton of wrappers and cups that had the TM and they wanted to utilize those before switching to the R. It does not mean that they don't have it trademarked. It just means that they haven't put their correct logo on yet. And then lastly, you've got service marks. So service marks have the SM logo. So this is claiming rights to a mark for intangible services. So with Subway, Pizza Hut, those are food. They have products. Services don't necessarily sell something physical. So a lot of times car washes, maybe insurance companies, other services, they'll use the SM mark, and Farmers Insurance uses theirs above. So that's just three examples to which you'll see symbols on different logos, designs for businesses that mean that their area is trademarked. Some more things. So like I said before, trademarks can not only be a word or a business name, but it can also be a slogan, it can also be a logo. So some trademarks include a word or design or the combination of both. So for McDonald's and Nike, they not only are known for their names of their business, but they're also known for their logo. When you see the golden arch M or you see the little swoosh, you know that that's Nike or McDonald's without ever seeing their words. You just see it from a mile away while you're driving, you know what store that is, or you know what business that is. So what they've done is they have not only trademarked their names, but they've also trademarked their design. They've also trademarked their design with their name. A lot of times businesses that choose to remarket themselves, whether they keep their logo, but they change their business name, or they change their logo, but they keep their business name, they will go through the system to re-trademark that. So if you're a business that's thinking about needing a trademark for your name, and maybe you have a logo as well, but you realize, oh, I'm not 100% dedicated to that logo. Well, one of the things we like to mention is you might want to consider waiting until you have a more set on logo, or if you do decide to trademark that logo today, then you switch it later on, you're going to want to reapply and get that new logo under a trademark. So something to consider when looking at business names and logos. There are other forms of trademarks as well. So these are a little harder to protect, I will say, and sometimes they take a long time to establish before you can protect. So just kind of keep that in mind. They're not as familiar, but it's good for us to always talk about them. So one thing is color trademarks. When you see that brown truck coming down your street and stopping, you know that it's a UPS. When you see that blue, baby blue box that maybe your boyfriend or fiance is going to open up and hopefully have a ring for you, you know it's Tiffany blue. Barbie pink is another one. When you see Coca-Cola bottles and you see the red, before you even know that it's Coca-Cola, you just know. So these are some examples. Also, sound trademarks are another thing. So the 20th Century Fox fanfare, that's considered trademark. The NBC chimes is trademark. Harlem Globetrotters theme song. Before we weren't allowed to go to movies, you would get to go to a movie theater and you would see the THX, dome noise. So all those sounds are trademarked. Other trademarks include smell and trade dress. So with smells, it's going to be more popular with perfumes, colognes. I will say, again, difficult to protect because I know like Chanel No. 5 is probably one of the most popular perfume scents that has been trademarked, but sometimes they change up their Chanel No. 5's chemistry and they make it smell slightly different. And if it doesn't smell just the right exact scent, then it may not be as protected. So just kind of things to keep in mind why it's kind of a little harder. Another thing that a lot of people like to use as a fun example is Play-Doh. Play-Doh has a very distinctive smell. So therefore, it's considered trademarked. There's a couple other things too, but yes, it's very difficult to protect. And then lastly, trade dress. So trade dress is product and service packaging and design. So again, bringing out the phone as an example. I have an iPhone, so this is perfect. So the rectangular shape of it, the fact that it has the rounded corners, the fact that it has that distinctiveness compared to other phones. You can't see the Apple logo, but you just know that it's an iPhone. Coca-Cola bottles is another example. Again, even without seeing the red or the Coca-Cola symbol, you look at that outline example that I have on the PowerPoint slide, and you know that that's a Coca-Cola bottle as opposed to Pepsi or Mountain Dew. So just kind of other things to kind of keep in mind. So I've talked a little bit about patents and why it's important for you to search them. And next I went into what exactly is a trademark. Okay, well, why is it important to search for a trademark? Well, like I said, with trademarks, you're looking more at businesses, whether it be goods, products, services, you're pertaining to business. So most likely you're an entrepreneur. Well, as entrepreneurs, you want to assess the availability of the mark. You don't want to infringe on anybody else, and you also don't want to have a likelihood of confusion. You don't want two Tommy's Tacos in the same area. That's gonna, create a confusion. Even if they're spelled differently, maybe they're completely different menus. You just don't want that to happen. You want to save time and money on the application, the lawyers, the litigation. So you don't want to apply and then come to find out because you didn't do your searching. You found out that, oh, there's already another Tommy's Tacos down the way, didn't even know, and now you just applied for something that you know you're not going to get. You also want to assess a commercial environment. You want to be prepared to discuss your mark, your goals with an attorney, or apply independently, pro se, by understanding the jargon like dress codes, class of goods and services. So trademark, I will say, we go through a lot of people that do tend to do this application on their own, as well as copyright applications. Trademark, I know I've known people that have done it on their own, patents, I've known people that have done it on their own, but patents probably are the most difficult application out of these different forms of IP, I will say. A lot of times people will ask for assistance, or they will go through the proper channels that we kind of tell them where they can go to get assistance. But trademark, a lot of people do tend to do it pro se on their own, but they want to be familiar with it. And that's kind of one aspect where those consultations that I was talking about at the very beginning kind of come into play. I can help you get a little bit more knowledgeable. So another thing is when establishing a business, you want to track your competitors. So maybe you're wanting to start up a taco business and you realize that there's a ton of taco businesses in your area that you're willing to start up. Okay, well, maybe you want to, kind of see where they're at. You want to look for marks that have been published that might be similar to yours. So again, you don't just want to check the database system that you use for trademarks, which is TESS. You also want to think outside the box. You want to look at local. You want to look at your area. You want to look outside the box. You also don't want to pick a name or logo or something that is similar. You want to make sure that if there is some similarity, that there's a difference between your goods and service, because that can make a difference too in the application process. Like I was saying, there's that risk of likelihood of confusion. So I don't want to go too depth into this, but this is a little chart that the USPTO had made that kind of explains the likelihood of confusion. So when you're thinking of a business name, you don't want to, you want to pick something that has that distinctiveness, that, and if it doesn't have a super distinctiveness, and there's that likelihood of confusion aspect that could come into play, you want to be familiar with these dynamics. So what first, the sound. Okay, when I say Tommy's Tacos, or T Marley, okay, well, T Marley, it could be the T with a dot, or it could be T like a golf tee. You want to think about the appearance of it. You want to think of the meaning. So this is an example of, if you use the Italian word, it means the same as woof in English. So if somebody speaks Italian and they hear that word, they might think, okay, oh, okay, that's an Italian restaurant or something. But for English people, maybe they speak Italian and they know the difference, and they think, oh, that's a woof restaurant. So just different things. The commercial impression. So if there's a logo aspect that comes into play with it. Also, you want to think about, okay, what else could it be called? So city woman, okay, well, woman could also be called the girl, it could be called the man. So just different things to consider when you're doing your searching and when you're thinking of your name. If I were to do Jessica's shop, okay, well, Jessica, some people call me Jessie, some people call me Jess. So if I were to tell somebody, oh, I just, started a business called Jessica's shop, well, somebody later on might tell somebody else, and then they might think my shop is Jess's shop instead of Jessica. So you want to make sure that when you pick a name, you're looking at all the different ways that you would think to spell it, say it, hear it, see it, all those things. So next, I kind of want to talk a little bit about what is considered a strong trademark and a weak trademark. So we talked about the likelihood of confusion. So this kind of comes into play with that. So strong trademarks, these are going to be your easiest to protect. They prevent that third-party use of the mark because of its distinctiveness. So these are the ones that if you were to get your business name trademarked or your service name trademark, whatever, this is what you're going to want to kind of strive for. So fanatical mark, so invented words with no meaning. Kodak is a good example. Before it became a camera and film shop, nobody knew what Kodak was. Arbitrary marks. So Apple, again with the Apple company. So to us, before they came along, it was just an apple, a fruit. You bite into it, it's tasty. A lot of people like it with pie. But Steve Jobs turned it into something completely different. And now when you think of Apple, you not only think of the fruit, but you also think of computer, phones, and technology. And then suggestive marks. So this suggests a quality or characteristic of a goods and service being produced. So KitchenAid is the example I like to use, and it's meant for kitchen appliances. So moving into weak trademarks, these are the ones that are going to be potentially a little bit more costly and difficult to police and protect. So when looking at all forms of different intellectual property or IP, you're going to want to make sure that you can protect it, because it's one thing to apply for it and pay the maintenance fees and to have it, but it's another thing to protect. And your application is only as good as you can protect it. So if you can't protect it and you can only pay for it, then you got to, make that business decision, weigh the cost. Is it worth it? Is it not? So when you have a weak trademark and it does happen to get granted, it could be a little harder to protect because you're more likely for infringement. It can also cost a little bit more too if you would have to take somebody to court. Not to say that people don't get weak trademarks granted though. Here's a couple examples. of things that have been granted in the past. So descriptive marks. Quick Dry is a brand name for cloth towels. It's very generic. It's very descriptive. It got granted, and it goes with cloth towels. It can also go with lots of other things. So I think that's probably where it got granted, but it might be a little harder to protect. Generic marks too. These are your common everyday names. So bicycle, if I wanted to have a bicycle shop and I just wanted to name it bicycle shop, that'd be very generic. Also aspirin, that's another generic word. So these trademarks can become generic after long-term widespread and are non-trademark use. So that's kind of where that aspirin example does kind of come into play. So with trademarks, there are two types of applications that you can apply for. One is the TEAS Plus and the other is TEAS Standard. So TEAS Plus, you're looking at $225 per goods and service. And then TEAS Standard, you're looking at $275 per goods and service. So goods and service, if I'm Tommy's Tacos and I'm only selling tacos, that's one goods and service. Let's say I want to also sell shirts. Well, shirts and tacos are two completely different goods and services. So therefore, I'm looking at $225 plus $225. So your application can add up for trademarks depending on how many goods and services you have. But the reason for the difference in pricing is Plus asks for everything up front at once. TEAS Standard, they may require more information regarding your application later on. Also, TEAS Plus is all online. So therefore, it risks that by mail process. It saves paper a little bit too. So it's all electronic. And also, if you are already in use in commerce as opposed to intent to use, so you're already using the business name, you already have started it and everything, being able to provide all that information all at once on your TEAS Plus application will also help it move forward a lot quicker. If you haven't started your business yet and your intent to use, you have like a 6-month window to provide some sort of example to which you've started your business. And then I think you can utilize that grace period up to 2 times before you would have to actually physically reapply. So with trademarks, if you're looking to trademark a name, a logo, whatever, there's 3 different types that you're looking at. So federal trademarks, this would be you applying online to the USPTO. You can search their database, their test database, to see what trademarks are already out there that could be similar to your own. This provides protection in all United States. So if you're a business that you're online only, or maybe you're looking to be online, but you also have one storefront or something, you're most likely going to want to use federal because you're going to want that protection throughout the US. You're selling to the whole US, so you're going to want that bigger, broader protection. You cannot claim infringement beyond the US unless registration also exists in other countries. So something to note with IP is I'm talking mostly about protection all within the US. If you're looking at foreign, it's going to be separate applications for each of these. And that's a completely different thing. So that's something that maybe pertains to you. I would recommend asking to talk to me about it at the end or send me an email about that. But that is something that we have tend to get questions about frequently. So also, its first use in commerce still applies. This is regardless of federal and state registration, common law use. The other forms of marks are state and common law. So state marks, this is going to be your local shops, your mom and pop shops. If you're looking to maybe have one storefront, maybe a couple different storefronts, but only selling to your state, you only want to stay local, you don't want to go outside Kansas, you just don't think you ever will, you might just want to apply for a state trademark. So this, you're going to go to this, you would register with the Secretary of State, and they have their own database. It doesn't have a specific name, it just has its own database, and you can search for names there. Now, you still might want to search at the USPTO test database to see, you know, what's out there that could be similar to yours that's in the United States overall, as opposed to just the Secretary of State database, but they do have their own databases. Also, geographic limitations to the state of use only. So like I said, if for some reason you did decide to get a state trademark, and then let's say 10 years down the road, you decide to expand with an online shop, you would either need to do a federal trademark, or you would need to realize that your protection is only held within the state. It's not held outside the state. And then cannot claim infringement beyond states of use. The last thing is common law trademarks. So these are not registered. These are trademark rights developed through use, preferably over time. Geographic limitations to states of use only, or smaller areas, and they cannot claim infringement beyond the state of use. So these are going to be a lot harder to protect because they're not registered, or they haven't been registered after a long time, and you're basically going off of establishability and how long that business has been established or that service has been established. So halfway through, I'm going to take a breather for a second. Also, I want to let you guys know that there is a chat feature to this Zoom session. So if you guys have any questions, you can put them in there, or I will be taking questions at the end. So just kind of want to keep that in mind. So halfway through IPs. So next, I kind of want to segue into copyright. So copyright, like I said, we've talked about patents. There's 3 types of them. They're probably the most in-depth application to get. They mostly pertain to inventions, sometimes plants, sometimes design aspects. Trademarks, those are going to be more business oriented. You're looking at names, slogans, logos. Those applications tend to be a little cheaper. You can tend to do them on your own if you'd like. Well, next I want to talk about copyright. So copyright is a little different. These last 2 actually are a little different and not as common or not as popular out of all the intellectual properties, but they're still worth talking about. So copyright, you can actually go one of 2 ways. Some people, they never register their copyrights, and others do. So we're going to kind of talk, go a little in depth onto what that means and how it's all protected and what exactly is copyright. So copyright is a form of intellectual property that protects original works of authorship that are fixed and tangible forms of expression and may include the following. So if you see in that corner the little C with a circle, anything that you see a C with a circle on, that means that it's copyrighted. So this can include, most familiar is literary works, musical works, dramatic works, choreographed works, pictures, graphics, sculptures, maybe graphic design, motion picture films, anything audiovisual, sound recordings, and architectural work. So basically, a lot of anything else kind of falls a little bit beyond this. Most familiar things that a lot of people see is, you know, publishing companies. There's a lot of copyright with that. Musical work, you know, if somebody's recording something, I know that copyrights talked a lot about throughout that. So here are some examples to which entrepreneurs, they may not be thinking, oh, copyright, this doesn't include me at all. But if you fall under any of these examples as an entrepreneur, then copyright does include you. So examples of copyright can be apps, software, web design, I talked a little bit about software and stuff in terms of how it could be trademarked or patented, but there's also copyright dynamics to it. Promotional photos, posters, business cards, promotional videos or ads. If your business maybe wants to take on podcasting, recording, interviewing, recipe books. So there is a difference, and we'll go in a little bit more in depth into this later on, but it has to be a recipe book and not an individual recipe. Blog posts, video tutorials, instruction manuals, drawings, maybe designs for fabric jewelry prints. So before you created your invention, the designs to the invention, that could be copyrightable. So what cannot be protected? So just an idea, something in your head, that's not protected. It has to be something that is in a fixed format. So let's say I have a story in my head, but I haven't written it down, I haven't told anybody about it, it's just in my head. That's not copyrighted. Now, the minute I put that story from my head into pen and paper, once it's been created, that itself is copyrighted. An invention. So this falls under patents. Obviously, an invention itself that's been created can't be copyrighted. It's going to fall within a different form of IP. Same with business name or slogan. This is going to fall under a trademark. A recipe or list. This doesn't contain original authorship according to people that grant it. So therefore, it would not be considered copyrighted. Now, if I were to have, let's say, 5 or 6 recipes, and each one of them had its own story, and I put the story with the recipe, and I created it into a bound book, now that's a different story. Hence why a lot of cookbooks have maybe stories in between their recipes at the beginning, have different elements, so it's not just recipes. And then also government works. So there are some exceptions that do apply to it. I actually work with government documents. So copyright and GovDocs, there's a lot to be said that kind of go intertwining with them. But so who can claim copyright? So copyright can be claimed by an author or co-authors of the work. This can include minors. It's those deriving rights through or from the author, such as publishers, record labels, etc. So sometimes you will see more than one person that have something copyrighted, and it's not just because they're co-authors, but maybe that author has copyrights, but because they sold it to a publisher, because they have a contract with the publisher also has copyrights to it. Same can be said for a musician that has a contract with a record label. The author's employer, if the work is a work for hire. So a lot of times, a more common question that I get a lot is, let's say you've got invention for patents and you know what you want to do, but you can't create it, you can't sketch it out or something. So you do a work for hire in which you have somebody that can draw the sketches for you. Maybe you have somebody create the thing physically for you, but you still have copyright rights to it as well. So kind of distinguishing that. Maybe for your business, you want to trademark your name and you want to create a logo, you know what you want, but you can't design it. So you do a work for hire with a graphic designer. Okay, well, distinguishing that copyright, who claims it, is very important, because a lot of times you don't want to infringe on their copyright because they're the one that created it, but at the same time, you're the one utilizing it. So I get a lot of questions in regards to how best to handle those situations. So a work for hire, like I said, is a commissioned work prepared by an employee within the scope of his or her employment. So other examples: event photography, translucent web design, portrait, sculpture. So like with event photography, a lot of times photographers, they'll do, like we had our photographer did our whole wedding for us. Well, she actually owns the rights to all of our photos, but how we chose to do the contract was not only does she own the right, but we do as well because they are photos of us. So some people, some photographers, they won't give the copyright unless you buy from them. There's lots of different things that go into that. So how long is a copyright duration? So copyright protection lasts for a lifetime of the creator plus 70 years for an individual. So the durations actually, older copyright materials may vary due to laws created. Copyright duration may vary depending on the country as well. So what are some benefits of registration? So, oh, I see a chat. So for benefits of registration, there are 5 things to kind of keep into mind. And this is something that we give LegalZoom.com the rights to. So public records of copyright ownership, sue infringers on federal court, establish evidence concerning copyright and the facts stated within the certificate. The owners of the copyright may seek statutory fees, attorney fees, and then record registration with US Customs. So a lot of times, like I said, some people won't necessarily copyright their work. Like one of my earliest examples, I have an idea of a story. Okay, if I keep it in my head, it can't be considered copyright. The minute I put it to pen and paper, let's say I put it to pen and paper and all of a sudden, here it is. Then that paper is copyrighted, whether I register it or not. I wrote it, it's in my handwriting, I can test it, like I'm the one that came up to it, nobody else did, like this is mine. But what you realize is when you don't register it, it's a little harder to protect. Not to say that it can't not be, but if you register it, then you have that public record. You can actually sue infringers in the federal court. You have that established evidence. You can see when I filed for that. You have that record with the customs. So it is important to register. Now, you don't have to, but it's going to be a lot easier and better to protect. Nope. Doesn't want to click my next. Okay, so we talked a little bit about registration fees for trademarks. I didn't go into it with patents just because there isn't really a good way to give you a direct number for fees. It very much depends on your earning, your income, how much help you're going to need if you need help, and all sorts of dynamics. Trademarks, it's a little bit more straightforward. Copyright, it is really straightforward. So to register online, you would go to copyright.gov. Since last spring, they have upped their charges, but it is still the cheapest form of IP you can ask for. So for a single application, you're looking at $45. For a standard application, you're looking for $65. And then for a paper, you're looking at $125. They are still doing the paper. You have to call and request though. And I do have a feeling that it will go away eventually because paper applications have gone away for patent and trademark over the past couple of years, and they are really trying to go electronic. But for now, copyright still remains the last paper application. So some additional fees to kind of keep in mind are group registrations. So more frequently, this is used for like if you're a songwriter and creating an album. You can do a group registration on all the songs in your album as opposed to just doing each song separately. Some people will do this with photos. They actually have a cap on how many photos you can group register with. So pre-registration of certain unpublished works, and then pay for record search or retrieval of records or copies can be other additional fees that you'd be looking at. So licensing your work. So this falls within copyright, but is a little slightly different. So a copyright owner may choose to allow others to use their work through a licensing. This may determine price, who can access, number of uses, length of use, how the work can be used, if the work can be modified, and if attribution is required. So this is being seen a lot more right now, especially with colleges, education just in general, mainly because of the big transition from in-person teaching as opposed to virtual teaching. So it used to be I got like 1 or 2 copyright questions a semester. Now I get a lot more. So with licensing, a good example for this would be, let's say you create a documentary, you get it copyrighted, you've got rights to it, maybe you sell it through Netflix or create it with Netflix, they've got copyright material to it. Okay, well, you want to put it on their list of licensed work that is granted to allow a classroom to use it. Maybe you create a documentary over the history of fans, and you want a design class that's working on creating fans to be able to use it or to watch it. So you create some sort of licensing agreement that can allow people that are using it for educational purposes to showcase it. Some people use licensing more popularly in publishing world. So maybe you create a textbook, you get it published, you create your own textbook, you get published. You want to allow classrooms to utilize it, but they can utilize it online only if they buy this many copies of it or something. So there's lots of licensing agreements that copyright owners choose to allow others to use. It just kind of gives them that ownership right, but it also gives people that are wanting to utilize their material a little bit of a buffer. Another thing to look at with copyright works is free use. So you may be able to use copyright material under certain circumstances without pertaining permissions. So this falls within Creative Commons. So seeing the license type to determine its use. Also public domain. So these are copyright protection that's expired. Copyright owner failed to renew or their copyright has expired. Copyright owner deliberately places it in the public domain. So public domain resurfaces every year, and basically anything in the public domain is free to the public. So this includes a lot of different works, but it also gives people ways to be able to utilize works that they couldn't utilize prior. So more popularly, why some people recreate different stories or recreate different films could be because it has gone within public domain or was put in public domain, and therefore they can recreate new versions of it. Government works is another thing. Some exceptions do apply again. There is the fair use exception. So this is generally used in educational purposes. And then there's commentary of the work. So creating something transformative, not derivative. So going into those things a little bit, Creative Commons license types. So here are 4 types. There are more, but these are 4 common ones. So if you see these symbols on anything, then that means that there's some sort of Creative Commons licensing to which you can utilize that material. So attribution, this allows others to use your work if you give them credit. Share alike, this lets others copy, distribute, display, perform, or modify your work, as long as it's just distributed or modified under the same terms. There's non-commercial. So this lets others distribute, display, perform, or modify your work for any purpose except commercialized use. So you can't sell it unless you obtain permission. And then no derivatives. This lets others copy, distribute, display, or perform only original copies of your work without modification unless you pertain permission. So this falls a lot, again, within the classroom setting, especially if you're creating some sort of work or design or something that could be used in the classroom. You might want to look at adding Creative Commons licensing to your copyrighted work. Next is fair use exception. So fair use exception, like I said, this is used mostly for educational purposes. So I don't want to talk a whole lot about it because I don't know how many of you guys that actually applies to, but this is a nice little chart that kind of goes over the broad overview. So you want to look at the factors of the fair use, whether it's one of these 4 things. And then you want to look at, okay, mine falls under purpose and character or nature of work, amount or market effect. And then you want to think, okay, why does it fall within that? And then if it favors fair use, then you'd be able to use it under fair use. If it favors permission, like let's say I want to use it for commercialization. Well, it's going to favor permission. So therefore I need to contact that company or that copyright person and see if I can use it for this example. Same with large amount of work. I'm using it largely, not in a small amount. I'm making several copies of it. You need permission over fair use. Next is first sale doctrine. So, or I guess I should say, lastly, this is first sale doctrine. So this is owning a physical copy. It's not the same as owning the copyright. So I am a movie lover, fanatically, and we have a ton of movies. So just because we own all those movies does not mean we own the copyright to any of them. Also, you may lend, sell, or dispose of a physical copy, but the copyrights are reserved for the copyright holder. So, you know, bookstores, they sell a ton of books, but copywriters to those books, they reserve the copyright hold. And then reproduction, publicly displaying or performing the work is not permitted. So lastly, we're on the final end of intellectual property. This is trade secrets. So again, recapping, talked about patents, talked about trademarks, talked about copyrights. All 3 of those forms of IP, depending on where you fall into them, you might fall into multiple. They all require applications. Some are on the cheaper end and easier to apply for. Some take extensive searching knowledge, maybe assistance to apply for. Trade secrets is a little bit different because it actually doesn't require an application, and a lot of people don't know about it. And so therefore, that's what makes it a secret and a trade secret, nonetheless. So what is a trade secret? Any valuable information that gives its owner a competitive advantage. So this can include formulas or recipes, marketing plans, customer lists, employee rosters, financial information or forecasts, etc. So biggest example would be Coca-Cola formula or KFC's chicken recipe. What kind of spices do they have? You know, maybe Dr. Pepper's, 23 flavor. What are those flavors? Looking at big companies like Coke Industries, maybe Textron, knowing what those employee rosters are, that could be considered a trade secret. Maybe their financial information could be considered a trade secret. So trade secrets can last forever if the owner makes an effort to keep it a secret. So again, with Coca-Cola formula, Coca-Cola has been around for like ever, it feels, at least my whole lifetime. So for Coca-Cola, they've really, done a good job of making a trade secret all these years. They've gone so much as to maybe this factory member knows all but half of the ingredients. This person knows the other half. they never meet, they're not allowed to talk, and to which it keeps it a secret because combined they don't know all the ingredients. Not registered with any government authority. So like I said, with trade secrets, because it is a secret, you're not telling anybody, you're not disclosing it to anybody. It is legit a secret. You don't need to register it. And then maybe enforced with contracts. So I would assume if you worked for Coca-Cola, you probably don't know all the ingredients. You probably know a handful, and what you do know, you were probably asked to sign a contract to which you can't state what those things are. Just kind of something to think about. So what are trade secret examples? So this could be other things as well. So pending patent trademark application. Let's say you create an invention, maybe you have a business name, you're starting up, and you don't want to tell anybody what it is because you don't want them to infringe on you or try to take it away or something. So you want to keep it a trade secret for now. That's a good thing, because keeping a trade secret means that, nobody else knows about it. It's just you. So that can help. Consulting, research, freelance, licensing, assignments, and non-disclosure agreements. These can also be trade secret examples. So like I said, some people might have to sign a non-disclosure agreement if you're a work for hire, or if you are doing a patent invention and you need help and you have them sign a non-disclosure agreement, that helps them keep your secret. That helps you make sure that they're keeping your secret. Pre-published writing, such as books, manuals, software reports. So like I said, if I create a book, pen and paper, okay, well, I have that copyright. Before I get it copyrighted, registered, it's a trade secret if I don't show it to anybody. Process, ingredient, know-how, that could be trade secret. So I mentioned KFC's fried chicken recipe, the ingredients to that. Maybe only one person in that company actually knows all the ingredients. Okay, well, they're carrying around the trade secret that everybody wants. Knowing what not to do. So negative information can be an example too. So how do we protect those ideas? Because there isn't a way to register it. So if you're not registering it, how do you protect it? Well, trade secrets are the only intellectual property where ideas can be protected. So this is useful for strategy, business ownership methods, and for ideas and innovations that are being developed for patenting. So it's critical to protect the ideas at this stage to prevent someone else from claiming inventorship, and to ensure that a public disclosure is not made of the invention. So you want, especially in forms of patents, not to say that it isn't important with copyrights and trademarks, but before you register it, it is a trade secret. As long as you don't publicly disclose too soon, or you don't disclose without signed agreements, or to which you're only talking with people that really have to know. So all of that helps kind of keep it that trade secret aspect. So with trade secrets, ooh, did I skip? Oh, okay. So yeah, so with trade secrets, you just kind of want to make sure that you're not disclosing it to too many people. So best example I've heard in a while has been, let's say you're a business. This is where people do tend to like think, oh, I'm keeping it a secret, and keep it, when I'm really not. So let's say you're a company business and you are a small business. You're just starting out, you're working with Marsha over at Small Business. Come see me, you're ready to take it to the next step or whatever. You've got some sort of fried chicken recipe of your own, and you're just going to keep it a trade secret, but you're marketing the name or whatever. But you ask me, hey, I've got this, secret recipe, only a couple people know about it and stuff. Well, I'm going to ask you, how many people are in your business? And you say 3. I was like, how many people know about your, or let's say you're a business of 5, you have 5 people. And I'm going to ask, okay, how many people know about the recipe? Well, I know all the ingredients. And then my 2 assistants know all the ingredients as well. Okay, that's 3 people in a 5 staff business company. Okay, well, 3 is more than 50% of your company knows what the recipe is. So therefore, it can't be considered a trade secret. Now, if you knew all the recipe and those 2 people only knew parts of it but didn't know the whole still, then it could still be considered a trade recipe. So those are just things to think about in terms of if your idea or what you have is really a trade secret or not. You want to make sure that, yeah, even if you are small and you're saying it's a trade secret, that really not that, like, hardly anybody knows about it. Now, in bigger companies, it's a little different. Like Coca-Cola, there's probably a handful of people that know about certain parts of it. Maybe not the whole thing, but certain parts. But therefore, it's still considered a trade secret because they're a way bigger company and so many more people that run and help run that business don't know about it. So that's my spiel on intellectual property. Next, I kind of want to go into some resources, just kind of a brief overview, closure for you guys before I take any questions. So if you find yourself looking through these forms of IP and think, oh, okay, one or both or multiple maybe are of interest to me, and you know you're going to need legal assistance, here is a way to find legal assistance through the uspto.gov website. They have, if you're looking for patent help specifically, they do have a patent practitioner search, so you can find an attorney or agent in your area or your state. Last I checked, I believe there's 4 for Kansas, but not all of them were taking clients at the time. Also, you can look at Pro Se assistant programs. So these are resources for inventors that are filing by themselves. This does include an application checklist. There's also the patent pro bono program. So if you're looking to do something patent related and you're needing legal assistance, this is a way that you could maybe see if you can get free legal assistance or discounted. Law school clinic program, this is generally free legal assistance with the exception of the application fee. And this is working with participating law schools. And we don't have a law school in Kansas that falls within this program, but if you look at the list of law schools, a lot of them either take clients that are from all over the US or from certain parts of the US. So there is some that take Midwestern states. We would be included in that. You just want to make sure that if you are looking to go the law school route, that you make sure that it is a law school that is helpful to your form of IP, because they do this for patents and trademarks. You can also look at scam prevention, and then there's a list of companies by the Federal Trade Commission that can help with filing a complaint if there's some sort of issue you're having with infringement regarding your IP. So next, I kind of want to talk into databases. So we talked a lot about why it's important to search and where that prior searching comes from. So just to kind of go over each of these a little bit more in depth, since I've got a little bit of time. So USPTO is going to be your big one. This is where anything United States related protection is going to come into play. PTRCs, we are sub-hubs for our headquarters that is the USPTO. So there you can go and search patents, you can search trademarks, you can find the legal help you would need, you can find my information since I'm your state representative, you can find all sorts of help. For, let's say you have decided your invention you not only want to protect in the US, but you also want to protect internationally. You are going to want to look at NSPOSNet or WIPO, however you want to say it. So the European Patent Office is SPOSNet, and then World Intellectual Property Organization is WIPO. So both of these databases are going to be great in terms of, well, one, if you just want to know if there's inventions that are like yours that are found outside the US and already patented. And then two, let's say you're a big company and you want to patent your invention not only in the US, but outside. You can go to these databases, do your searching, see if you want to apply in specific states or if you want to apply in a treaty, to which you could file an application that would kind of help. Instead of doing multiple, you're doing once for so many different states. Second to the last, I want to talk a little bit about Google Patents. So Google Patents is actually, I kind of prefer it a little bit better than USPTO. I still say you should use both, but I like to start with Google Patents and then work into USPTO. So Google Patents is different from just normal Google. As you can tell below the logo of Google, it says patents. That's how you know you're on Google Patents. You can also go to patents.google.com. So this is not going to just show you US patents, but it's going to show you around the world patents. Also, if you scroll down to the very bottom of their page after searching, you'll see like this little grid, and it can show you like the top 3 companies that are patenting products similar to yours, who are the top inventors, and so much more. It's basically like Google, but for patents searching only. It's also a lot like user-friendly than some of these more complex databases. And then lastly, there is free patents online. This is just another generic patent database system for you, or if you want to see if anything pops up there, as opposed to the other database systems. Like I mentioned in the very beginning, as a PTRC library, we do have research guides that I've created for you guys. Here are 3 in particular that might be of interest to you guys. One is the Patents, Trademark, and Copyright Guide. So these PowerPoints that I'm doing for this workshop series, they're actually on our research guides, as well as links to the databases I've mentioned, links and definitions and stuff to all forms of IP, basically just a nice little self-help online booklet for you. The Entrepreneurship Research Series, this is something that me and our business librarian and the engineer librarian, we were doing together in person since COVID. We've taken a break from it. We are hoping to bring it back in the fall, but with the transition of a new engineer librarian this semester, and with me and the business librarian doing so many workshops through other organizations, such as this one right now that I'm doing, we're still just remaining solely online at the moment, but we're hoping to bring back something in the fall, whether it be Zoom sessions or in person or both. But for right now, that's just a guide to kind of help give you information on other series workshops. This is a workshop that I do for that series, as well as I do one for patents, trademark, copyright. I do one for patent searching, and then our business librarian, she does one for graphic design tools and how to create a business plan. So if any of those things interest you, you might want to look at that website. And then lastly, our business librarian, Megan Coleman, she has created an entrepreneurship guide for any of you guys that are logged in that are business owners. This just gives you a lot of different information and things we offer, and things that links to things that she thinks would be helpful for you guys to note, whether you're student, faculty, or in this case, community. So we do have a lot of community resources as well. Below is my contact information. So as of right now, my email is still jessica.torres@wichita.edu. In the next 2 weeks, I'm hoping to have it switched to Pierpoint, but it's taken a lot longer to change my name than I had expected. So I'm still in transition. But if you go to libraries.wichita.edu, and I will put that in the chat right now, you can look up my name. If you go to any of these guides, there's actually a like little picture of me on the side, and you will see my name pop up, and you can shoot me an email that way through the guide. My number right now, since I am working solely, well, not solely, but mostly remote, I'm not really, I am checking my phone, but only about once a week. So therefore, I did not put my phone number on here, but it is listed on our web pages. So if you would rather use phone, you can go to the library website and call me that way. But right now I'm trying to take most of my stuff via email. Like I said before, I do a lot of Zoom consultations nowadays. I do phone as well if I have to, but right now it's mostly via Zoom. And then that is my session. And if, since we have about a little less than 15 minutes, if there are any questions you guys have, you are more than welcome to ask away. Either type them in the chat or you can unmute yourself. But I will stay on for a little bit for questions. Otherwise, I hope you guys all learned something and found this very useful. Like I said, I do consultations. If it's not something I can help you with, then normally I can refer you to who might be helpful. I know with Kansas Small Business Development Center, there's a lot of tag teaming that we do, a lot of referrals back and forth we've done in the past, because especially with trade in relation to trademark and stuff. But yeah, if I can be of any assistance to any of you guys, don't hesitate to try to reach out. And I think that's all I've got for now. And like I said, I'll stay on here for a little bit. See if there's any questions in the chat that pop up, or if anybody needs to unmute themselves. Marcia, if you want to say any last minute words, you're welcome to.
There I am. Okay. Now, I just wanted to remind everybody that Jessica is doing 2 more workshops in this series. Patent Basics next Thursday, and Trademark Basics the Thursday after that. Same time, 3 to 4:30, and both of those are free webinars. So if you want to delve a little deeper into patents or trademarks, just tune in, register the same place as you registered for this webinar. I'm not seeing anything in chat, and Jessica, I really appreciate your expertise and your presentation, and I think you can wrap it up anytime.
Okay, sounds good. Yep. Like Marcia said, I'm doing 2 more sessions, one solely on patents and one solely on trademarks. So if those 2 interest you guys at all, feel free to register for them. Marcia will send the links like before, as well as the PowerPoint slides for those. I did include in the chat the link to the research guides. But other than that, I think that's all I got. So we can wrap this up. Thanks for attending.